You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Ms. Johnson, in cause number 25, DCCR 1826, you're charged with the second-degree felony offense of robbery, and that's from October 14th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet in that case some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tender's number 1 in that case.
No objection.
It's admitted. Any evidence that Ms. Johnson's not competent?
No, Your Honor.
Right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of robbery. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Correction.
But we can just proceed on count 1 in each one of them to our pages.
Okay, thank you. Ms. Johnson, in cause number 24, DCCR 2151, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 6th of 2025 for the third-degree felony offense of forgery of a financial instrument. And that was a 6-year deferred probation. Is that correct?
Yes, ma'am.
And then in cause number 24, DCCR 2152, I also have a motion to revoke your unadjudicated probation. Shows you were placed on probation October 6th of 2025 for the state jail felony offense of abandoning or endangering a child, and that was a 5-year deferred probation. Is that also correct?
Yes, ma'am.
And then in cause number 24, DCCR 2153, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 6th of 2025 for the state jail felony offense of abandoning or endangering a child, and that was also a 5-year deferred probation. Is that also correct?
Yes, ma'am.
Each of these cases allege, and the state's elected to proceed on count 1 only. They all allege that you violated your probation in count 1 by committing the offense of robbery on October 14th of 2025. And is that true or not true?
Sure.
Did you enter your plea of true to count 1 in each of those cases freely and voluntarily?
Yes, ma'am.
And did you plead true because that's actually true?
Yes, ma'am.
In all 3 of those cases, I also have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed those, did you also go over them with Ms. Holmes?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow these agreements that you also will be waiving or giving up any right to appeal?
Yes, ma'am.
State tender's number 1 in each of those cases.
No objection.
It's admitted in each case. All right, Ms. Johnson, in each of those cases, I'm going to find that you entered your pleas of true to count 1 freely and voluntarily. And clause number 24, DCCR 2151, find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of forgery of a financial instrument. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24, DCCR 2152, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of abandoning or endangering a child. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in cause number 24, DCCR 2153, find sufficient evidence to find you guilty, and at this time find you guilty of abandoning or endangering a child. Sentence you in accordance with that agreement to a term of 12 months in the state jail prison. You'll receive credit on that for any time that you've been in custody that the law gives you the right to receive. All 4 of these cases will run concurrently, which means together at the same time. I'm going to hand you in each of these cases. I did one more print. Are there 4 there already?
Yes, ma'am.
I'm going to hand you the trial court certifications in each of the cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, ma'am. You can go back with the bailiff. Thanks for being here. Time to take a break.
Good morning.
Good morning. Morning.
Still is a good morning, sir.
Well, that means he needs to be here. I'm just telling him what you know. Okay, so I need her in here real quick, please. Apparently, Mr. Smith didn't sign a waiver. So,
Is that correct, Charlie, or am I wrong?
I did not see one in.
So just call and I'm ready, so that it's gonna appear via calling. He's gonna be on the conference call.
I'm just not sure that that is that acceptable appearance, but, I think it would be better if they can Zoom and they need to go. I need to see his.
Because he needs to go with him if he did not. Okay, thanks.
Give them a minute and see if they can zoom in. You've got Anthony Whitmire, Mr. Rojas. Oh, I don't have that paper yet. Let me hold it just a minute and I'll call it.
Think you hold up on Whitmire?
Are you ready for Whitmire? We're ready.
Okay, you can go ahead.
Thank you. I'll take it.
Useful papers. Wow.
And we're just going on the possession case.
Yes, ma'am.
Good morning. Are you Anthony Whitmire?
Yes, ma'am. Good morning, Your Honor.
And Mr. Rojas, will your client with the formal reading of the indictment?
He will, Your Honor.
Mr. Whitmire, in cause number 25 DCCR 0057, you're charged with the second-degree felony offense of possession of a controlled substance from October 12th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Whitmire is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance, sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that for any time that you've been in custody that the law gives you the right to receive. I'm going to sign a dismissal as part of this plea agreement and clause number 25 DCCR 0056. I've handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Just thinking about yesterday, and this is a possession case, so I'm not sure how it applies. But because of the judgment entered against you, you could be ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas and read that document carefully. All right, you can go back with the bailiff.
Thank you.
See, and so am I gonna have to start modifying? I think I'm safe just saying it, and
It's like a
it,
citizenship thing, because you can't control whether it does or doesn't.
I know.
Being readmitted.
But I mean, they've said specifically that possession is not one of them. In the Hambry case.
It really more says case by case, and I don't think it's such a blanket.
I would continue to give the.
I'm gonna say, yeah, as I was saying it, it made me think. Okay, make sure you send that dismissal over on Whitmire, please, and I'll get that signed. And then as soon as hopefully they're gonna zoom in on Norris.
Mr. Ernest is a plea also, Judge, if you have it.
Okay, Brendan Ernest. Brendan Ernest. Let's see, we're going on 3 out of the 4. 2.
Everything is very long.
Well, yeah, that makes-
Good morning, are you Brendan Ernest? And Mr. Rojas, will your client waive the formal reading of the indictment in each case?
Here we are.
Right, Mr. Ernest, and cause number 26 DCCR 0429, you're charged with the first-degree felony offense of aggravated robbery. And that's from February 20th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? Then, let me take a second. And cause number 26 DCCR 0430. You're charged with a third-degree felony offense of obstruction or retaliation from February 12th of 2026. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they've charged you with? In cause number 26 DCCR 0908, you're charged with a second-degree felony offense of robbery. And that's from February 12th of 2020. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? In all 3 of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
So you can't change your mind if I follow the agreement. You understand?
Yes.
And it looks like the agreement that you've reached in all of these cases would be for 10-year deferred probations. There would be $500 fines in each case. There would be a dismissal in cause number 26 DCCR 0431, and you would be required to follow all the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Ernest is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. Find sufficient evidence to find you guilty in each case, but I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing.
Yeah.
All right, you can go back with the bailiff. You've got Vicente Gloria, Mr.
I
Rojas.
think that was reset.
It was, okay. Who's is that? Oh, that one's a lot. All right, let's let me figure out how to get this done. Second. Good morning, ma'am.
Good morning.
Good morning, Judge West.
Good morning, Mr. Norris. How are you doing?
You know who this is, don't you?
Yep, I know who you are. You're Christopher Norris, right?
Yes, Christopher Stevens Norris.
All right, so this is cause number,
Yeah.
hang on just a second. Let me go through some stuff. If you have something to say, I'll give you an opportunity, okay?
Okay.
And you should be able to see on your screen, Mr. Rojas is here, your attorney in court. Mr. Nichols is here representing the state, and this is cause number 0184078. And Mr. Norris was found not guilty by reason of insanity of the offense of murder back in February of 2006, is currently at the Russ State Hospital. And this is our yearly hearing under Article 46C of the Code of Criminal Procedure. I am going to take judicial notice of the court's file, including all of the previous hearings and reports. In addition, I have received the most recent report. I have a forensic psychiatry report to the court, which was prepared by Dr. Gerke, dated June 10th of 2026. The finding in that is that Mr. Norris, that further inpatient treatment would be recommended, and that it is not recommended that he be released to live independently at this time. And then in addition to that, I have a physician's certificate of medical examination for mental illness from Dr. Gerke. The finding in that is also that Mr. Norris is mentally ill, that without inpatient treatment likely to cause serious harm to others. And there's several notations here with some issues that have occurred between now and our last hearing a year ago. Is there any other evidence with regard to further treatment inpatient at this time, Mr. Rojas?
No, Your Honor.
Mr. Nichols? Give me just a second to all right. Then I am going to find at this time, based on the reports, that Mr. Norris is mentally ill and that further inpatient treatment is required based on I'm sorry, I'm trying to read and talk at the same time. That he does not meet the traditional civil criteria for recommitment, but based on his current forensic type commitment, continued inpatient treatment is required because of the acquittal by reason of insanity with regard to the charge of murder. And that the specific finding is that without that, he would be likely to cause serious harm to others. And therefore, I am going to order the 1-year commitment.
You know, time to talk. Thank you, gentlemen. I have plenty of paper here I want to explain to you. You know that I have been locked up for 5 years, 8/13/2021 to 8/13/2026. I've been locked up 5 years. On August 13/2026, I'll be locked up for 5 years exactly.
So, Mr. Norris, here's the thing, we tried several years back,
No,
I, in fact,
that was 5 years
hold on.
back.
Yep, and that did not go well, and so all I can do at this time is base my decision on the history and the fact that I did, based on, at that time, it was everyone's recommendation that you be released to a kind of an outpatient, more relaxed situation, and that did
Yeah,
not work.
I was
And
on
so I
the
ordered you
step
back
down
to Rusk.
program. I got paperwork showing it says, while I was at Rusk Hospital, I take my meds, take all my meds, learn everything about meds and symptoms, learn my strengths and weaknesses, focus on mental health, take meds, keep appointments. I mean, I do everything that I'm supposed to be doing this year for
Well,
sure. Work
well,
on
and
my, work on my goals while I was at this hospital. I've been working on my goals. I understand that mental illness diagnosis is lifelong. Recognizing my symptoms when they are active. I mean, I got plenty. So I'm on resources, housing, transportation, food, clothing, support, medical service. I mean, I got all kind of stuff right here saying that I've been doing in the community, stay away from drugs and alcohol, stay in touch with court. I know that I gotta stay in touch with you if I get out because I know that
so,
you
Mr.
know,
Norris, let me interrupt you real quick, Mr. Norris. I can tell you now that if the doctors are not recommending that you be released,
yeah, I
then
really
I'm not.
consider. I haven't talked to that doctor for almost 6 months.
Mr. Norris,
I've been asking for another doctor, and what he wrote up was 6 months back because I've been trying to get another doctor.
I've made my ruling at this time.
What is your ruling?
My ruling is that you're going to be continued inpatient at that facility until further order of the court. If something happens and the doctors recommend some other outpatient or
What if I don't feel safe at this facility anymore? What if I don't feel safe here no more?
then you need to talk to that facility. I'll talk to Mr. Rojas and we'll look into it. All right? The hearing's over. Thank you.
Yeah, it's wrong though. It's wrong. That's all right.
Keep doing what you're supposed to do and potentially in some
I
time in
have
the
been
future.
doing what I'm supposed to be doing. I have been doing what I'm supposed to be doing.
Well, all right.
That's what I'm trying to tell you right now.
I understand. Continue to do that, okay?
So you just, anything anybody else tells you, or you pull up, and it doesn't even make sense what you said about the doctor overruling. I haven't seen it for 6 months. How can you write all this stuff about me?
We'll look into that, but the report that I have is dated June 10th. And so that's what I have to go by. And so I'm going to, again, I've made my decision.
That's gonna be
and
a decision every time I come in front of you. I don't feel safe at this hospital.
Okay,
That's what I'm
we'll
trying to
check
tell
into
you.
that. All right, thank you. We'll check
You
into
never
that.
check into it.
Good morning. Are you Tasia One Mac?
Yes, ma'am.
And this is cause numbers 24 DCCR 1046 and then 26 DCCR 0085 and 0086. Mr. Mack is charged with criminally negligent homicide. And then those last two are both bell jumping and failure to appears. Mr. Smith, what is the announcement?
Got a week that we signed.
Oh, yep,
Rejection.
there it is. Sorry, they were just coming through. Let me go through then. All right, Mr. Mack. And cause number 24 DCCR 1046. You're charged with the state jail felony offense of criminally negligent homicide. And that's from March 10th of 2024. And what that means, sir, is that if you go to trial and you're found guilty in that case, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
And then in cause number 26 DCCR 0085. You're charged with a third-degree felony offense of bail jumping and failure to appear from December 15th of 2025. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And then finally, in cause number 26 DCCR 0086, you're also charged with a third-degree felony offense of bail jumping, and that's from January 5th of 2026. Same thing, if you're found guilty in that case, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
In each of those cases, I have here on the tablet plea bargain rejections that you've signed with Mr. Smith that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty for a 2-year term in the state jail prison on that state jail case, and then 5-year terms on the other 2 bail jumping cases, all to run concurrently or at the same time. You have every right to reject those offers and have all of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter pleas of guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject those offers and have all of your cases set for trial?
Yes, ma'am.
Has everything discovery been, you've gotten everything you need, Mr. or everything they have as far as you know?
Half, Your Honor. However, just to, this, court will know, due to my hospitalization, I truly believe that these cases can be moved if we can get an offer of probation. That is, that is not the case at the moment, but that's where we're at. Just this is the first offender. He's eligible for probation from a jury. Right now, Mr. Coleman is only recommending print time.
Do you know, Mr. Nichols, who, is this going to be yours or you just covering
I don't.
today?
I don't know who ultimately it's gonna be assigned to a judge. I know, I mean, it's a homicide case, so I wouldn't expect that part of the offer to change.
Well, except though that the witnesses are going to testify that the shooting is.
Well, that's all between y'all. I don't need to know
Okay.
what all that is.
Okay.
At this point, what I'm going to do is put it on the trial docket.
Okay.
Obviously, if something changes between now and then, I'd rather take care of it well before. So whoever gets assigned to the case, or if Mr. Coleman keeps the case, but either way, if something changes, then y'all let me know. We'll move the case up. Otherwise, we'll take a look at it again on the pretrial date. And then after that, we'll get set for trial.
Thank
Or we'll set up for trial now, but we'll discuss it again in pretrial.
Thank you.
All right,
Thank
you
you.
go back with the bailiff. Mr. LeBlanc, you've got Samuel Harmon. Morning. Good morning, sir. You're Samuel Harmon.
Yes, ma'am.
And this is cause number 25 DCCR 1019. Mr. Harmon's charged with aggravated assault with a deadly weapon. And 26 DCCR 0385 charged with assault of a public servant. And what is the announcement?
Yes, he wants to trial. I've conveyed them.
Is the offer, let's see,
Judge, he had previously rejected 15. I re-urged that today.
Okay.
This is their first appearance with this newer charge
right?
that was indicted in March. And my offer was for them to run concurrent.
So 15 years in each to run concurrent.
Yes, Your Honor.
And so when we've gone over this before, Mr. Harmon, when it was just the one case, that if you're found guilty in either of these cases, the range of punishment would be that of a habitual offender, if that prior criminal history is correct, which means your minimum punishment would be 25 years in prison up to 99 years or life. And you understand that?
Yes.
And you understand the offer of that 15 years is now for both cases to run concurrently or at the same time. You understand? And you want to go forward on both of those cases to trial. Is that correct?
Yes, I was one time though to hire an attorney, my people are gonna give me an attorney.
So here's what I'm going to do, just because this has been going on for some time. Obviously, if you get an attorney hired, they can step in at any time. They need to do that as quickly as possible because I'm going to move your cases to the trial docket.
Yes.
Mr. LeBlanc will begin preparation for trial. And if they get someone hired, they'll substitute in. Otherwise, he will go ahead and be prepared, when that trial day comes up, okay?
Okay.
All right.
And,
you
and
pre-
Judge, also that second case, I believe it could be, they try that and then you can turn around, and try the next one as well.
Yes, Judge, we'd be seeking to stack.
So, Mr. Harmon, also, and I know you've gone over that with him as well, Mr. LeBlanc, that if you're found guilty in both of the cases, because those are different offense dates, that the cases could be stacked or run consecutively. If you're given a sentence in one and then they go to trial in the next, then the district attorney's office can ask me, and then it's up to me if those cases are stacked or run at the same time. Do you understand?
So it would be stacked, not concurrent.
Well, it would be up to me. So it depends on, if we go to trial on both of those cases, I would hear all the evidence in both of the cases. And if I decide that whatever sentences you're given in each of those cases, if I think they need to be stacked, then that's up to me. It's not a jury question, it's a court question. Okay, the plea agreement, if you wanted to enter a plea, is negotiated that they would run at the same time. If you wanted to take the plea deal.
Oh, okay.
But if it goes to trial, then it becomes up to me if you're found guilty in both. Does that make sense?
Yes, ma'am.
Okay, and you want to go to trial?
Yes, ma'am.
All right, we'll get it set for trial, then you can go back with the bailiff. Mr. Lewis, you have Jason Weinberg, it's a sentencing.
Yes, fine.
Come on.
Yes, was there that yes, yesterday, and I think it's the same like what he didn't.
Oh, did they not do an? You're right, we didn't get an update.
It's the same one.
So I put him in custody, so he didn't show for the PSI, and I put him in custody so they could go do a PSI, but I didn't get any kind of update. And I didn't notice that. So this is Jason Weinberg, and we had the pre-sentence report done, but he didn't show up. So I put him in custody for them to do that part of it, and I don't show that we have that. Can you check on that for me? And I'll hold the case and see if did probation go out and talk to you? All right, I'm gonna reset it 1 week. I need somebody to get out there this week, talk to him so that we can get this taken care of next Tuesday. Please, ma'am. All right, somebody will be out there this week. Sorry about that. Stacy Tyler, Mr. Lewis.
Yes, ma'am.
Good morning, ma'am. Are you Stacy Tyler? Yes, ma'am. And this is cause number 26 BCCR 0800. Ms. Tyler is charged with aggravated assault with a deadly weapon. Mr. Lewis, what is the announcement?
Judge, I've been talking with Ms. Tyler, and initially I was thinking it was just some mitigating information I was gonna be getting to the state, but there is some that is material to the facts of the offense. And so I am asking for a little more time to do that, especially considering what the offer is from the state and her exposure.
Okay. And do you already have that, or you're waiting to get that from?
I am waiting on a little bit of it,
Okay.
so but it shouldn't take me too long.
Okay, so I'm just gonna do a normal reset, Ms. Tyler, so that Mr. Lewis can get all of that information from you or whoever's getting that to him, get that information to Mr. Nichols, and then we'll get an announcement at the next court date, okay? You can go back with the bailiff. Janae Landerlow, Mr. Lewis?
And we're not gonna need her out.
Hold on, okay,
That's a situation where initially she was set for competency, but had refused to see Dr. Capone.
mhm,
I've gotten that worked out to where they can come over and see her at the jail, see her here.
Oh, I thought that was
And,
already gonna get done.
we were trying to see if we can do it next week. I've been talking with Dr. Bufon's
Okay.
office.
Okay,
We're trying to see if a date can be known where she can be brought over next week.
Sure.
I need to give Kelly on that.
all right, we'll just reset, a normal reset, and we'll get her brought over next week. We're not in trial next week, so it shouldn't be a problem.
Okay.
Mr. Parker, you've got Jacoby Murphy.
Jacoby Murphy. Yeah. We get the point.
Oh, God, you're right. That's why I didn't give you a breakfast taco. On 23rd? Yeah.
Good morning. Are you Jacoby Murphy? And Mr. Parker, will your client read the formal reading of the motion?
He will, Your Honor.
Mr. Murphy, in cause number 23, DCCR 0900, I have a motion to revoke your community supervision. Shows that you were placed on probation April 1st of 2024 for the offense of theft of property, a state jail felony. And that was, could you make sure, hold on, could you check that now?
Commentary VO***. And this is where the courtroom delivers one of its clearest messages. Probation is a second chance, not a free pass. The defendant has already been given opportunities to turn things around, but repeated violations can eventually force the judge to choose punishment over rehabilitation. The real question is, after all these warnings and chances, will this be the moment that finally changes everything?